time, please. My name is Patrick McInerney. I'm serving as the presiding judge for this panel. I was formerly district judge here in Johnson County, and before that practiced law here in the area, and now sit on the Kansas Court of Appeals. I'm with Judge Joseph Perrin, who's also a member of our court, and also the currently third longest serving judge here in the state. And he is originally from Olathe, which is reportedly in Johnson County. I'm also with Judge Kim Schroeder, who is a member of our court and is originally from southwest Kansas, where he was the district court judge in a 6-county district, so he is used to traveling around. We're here as one of the several panels of the Kansas Court of Appeals that's hearing cases this month. There are 14 members of the Court of Appeals, and we sit in panels of 3, which means 14 divided by 3 doesn't work out. But we do have senior judges that help us out on our docket. We sit all around the state. We've, in the past, we've arranged to sit in every judicial district in the entire state. So we travel all around to hear cases and to bring the Court of Appeals to the people. We have a heavy docket of cases. We're going to hear this afternoon only 2 orally argued cases. The third one on the docket settled yesterday, so we don't have benefit of argument on that one. But in addition to the argued cases, we have other cases that are not argued, that we consider strictly on the briefs that have been prepared and filed without the benefit of oral argument. So our workload consists of more than what you see here on the surface of these argued cases. We're a high-volume court. We try to get all our opinions out in the course of 60 days. Because we handle most of the appeals, we tend to be the final stop in the appellate process for most cases. It's a minority of cases that wind up going on to our Kansas Supreme Court. The 3 of us all came here to the Court of Appeals through the merit selection, nonpartisan selection process of a nominating commission that evaluated our credentials and selected 3 of us to be considered for a judgeship. That process has been changed for judges on our court. Now, the governor is free to appoint whomever he wishes to the court, and there is no intervening screening process by the merit selection panel. We are not products of that later system. There is a move to do the same thing with the Kansas Supreme Court and do away with the merit selection process. And because the appointment of Supreme Court justices is a matter provided for in the state constitution, any change to that will have to be by a vote of the people on a constitutional change. So I just alert you of that fact because it may be coming up sometime in the future because of antagonism among certain groups to our Supreme Court over perceived wrongs, and we are products of a different system, which we find to have been a worthwhile process, and that's the end of my editorial on that topic. With respect to our 2 cases this afternoon, as I'm sure the lawyers know, we have read the briefs. We have a pretty good handle on the facts. Use your time however you wish. You don't need to spend a lot of time on the facts. Quite frankly, for the benefit of our student audience, it may be helpful, though, to just give them a brief overview. I'll provide you with a little leeway on your time to accommodate that, particularly since we've lost our 3rd case. we can do that. And I'm not too good at keeping time anyway. You have 15 minutes aside. If you're the appellant, please let me know if you want some rebuttal time, and I'll keep track of that for you as best I can. Let's see, our first case for this afternoon is number 112925, Charles Dawson versus Burlington Northern Santa Fe Railroad. Will the parties state their appearances, please?
Marianne Hall for BNSF Railway Company.
I'm sorry.
Marianne Hall for BNSF Railway Company.
Oh, I hear you. I see. You've been admitted, Pro Hoc?
Yes, sir.
Very well.
Your Honor, Steve Groves, I will be arguing for the plaintiff. Also present is Davey Walker.
Very well. All right. You may proceed, counsel. This one's set for 20 minutes. So if you desire some rebuttal time, just tell me and I'll keep
Well,
track.
what I was going to ask you for would be 15 minutes on the original argument and 5 minutes in rebuttal, if that works.
That's perfectly fine.
All right. Thank you. Good afternoon, and may it please the court. My name is Marianne Auld, and I represent BNSF Railway Company in this appeal from a judgment entered against BNSF under the Federal Employers Liability Act, which is called the FELA. Respectfully, Your Honors, this is a case that never should have been tried. In fact, it never should have gone to a jury. And the primary reason is this. As a matter of law, Mr. Dawson's FELA claim was not timely filed. Specifically, Mr. Dawson failed to meet his burden to prove that he filed his FELA claim within 3 years of the date that it accrued. To the contrary, the evidence conclusively established that Mr. Dawson filed this lawsuit more than 3 years after he knew of his injuries and that his work was a potential cause of those injuries.
Counsel, is that issue that the case was filed too late, was that a factual issue that was submitted to the jury?
That is an issue that was submitted to the jury, but it should not have been. As a matter of law, the trial judge had the information that he needed in order to keep this from ever going to the jury. This is a case, as I said, that should not have been tried at all because Mr. Dawson did, as a matter of law, file his case too late.
So your argument is that the statute of limitations had already run and that this was so obvious and that factually there was no other way that it could be viewed?
Yes, Your Honor. Factually, there was no other way that this could have been viewed because conclusively the evidence established that it was filed too late.
Well, we have, you're relying upon statements that he made to Dr. Wickham, for example, that his pain hurt because it was worse when he was from rough riding on the engine. Statements to Mr. Munch about his pain related to the locomotive seats that he was sitting on and the rough tracks that the train was running on, and a couple of others. Did the plaintiff admit that he made those statements in summary judgment?
Yes, it is uncontroverted. The record is clear that these statements were made. And to step back just a little bit to come at this in an angle that may make a little more sense. Judge Perrin, you mentioned this being a statute of limitations. It sort of is not. And the reason I say that is this. Under the FELA, we don't have a traditional statute of limitations the way that we think of it in other areas of the law. Ordinarily, a statute of limitations is something that a defendant would raise by way of affirmative defense. Under the FELA, it is an actual element of the claim that the plaintiff, the alleged injured party, actually prove that he filed his claim within the 3-year period after that claim accrued. And so the burden, rather than being on the defendant, here BNSF, is on the plaintiff, Mr. Dawson, to prove that he timely filed his claim.
Just so I understand, more for the benefit of our audience.
Correct.
The plaintiff was worked for the railroad, was riding on locomotives, and he contended that because of the rough riding nature of the trains and the tracks that they were passing over, that he suffered injuries to his back that disabled him?
Yes.
That's what this is all about?
Primarily, yes. Mr. Dawson was an employee of BNSF off and on for a number of years. It wasn't a continuous period of time. There were different periods of time where he did other things besides work for the railroad. But over the period of time that he did work for the railroad, he worked as a switchman, he worked as a brakeman. Those didn't require as much time sitting on a locomotive as the time that he spent sitting on the locomotive once he became a conductor later on, and I believe that was in 1995. He claims that he has cumulative injuries to his back as a result of riding on the locomotives. He also claims that there were a couple of incidences where he suffered acute injury because of some rough riding on the trains, where there were specific instances that led to a further aggravation of his injury. And so that's,
And those aggravations are within the 3-year limit.
not from our perspective, Your Honor, no, because they were the aggravation of an existing injury.
I know,
And so they
but-
don't start the limitations period running
I'm just
again.
saying that those 3 points of aggravation occurred within the 3-year window of him filing his lawsuit.
Yes, they were in 2008 and 2009, yes. But legally, of course, BNSF takes the position that those did not restart the statute of limitations because the alleged injury from those instances was to the very same part of the back that already had been injured, according to him, by this cumulative shaking and vibration from the train. So when we're talking about this, we have to look at it as 2 separate things. We have the cumulative injury, we have the acute injury, and so how do we properly analyze whether or not the claim was timely filed? Well, let's take the cumulative injury first. There is the discovery rule that applies to those cumulative injuries. And as I said, Mr. Dawson bears the burden of proving that his lawsuit was filed within 3 years. Now, what does that mean? There's no disagreement between the parties on what the standard is here to determine the accrual of an alleged cumulative injury FELA claim. According to the discovery rule, the 3-year window begins to run when a plaintiff knows or has reason to know of the existence and cause of the injury that is the basis of his action. This court said that in the Christensen case back in 2012. The standard is an objective one, and it imposes on a plaintiff an affirmative duty to exercise reasonable diligence and investigate the cause of the injury. Ultimately, this is a 2-part test. The first part of the test is that the plaintiff is deemed to know of an injury when the accumulated effects of that injury manifest themselves. The second part is that the plaintiff has an awareness of the potential cause of the injury and knows that the injury is work-related. Let's talk about the first part first. Did he know that he had this injury? Yes. As our brief explains at page 8, the evidence is conclusive that Mr. Dawson knew that he had a permanent progressive injury long before 2008. Just to hit some of the highlights, in 2001, Mr. Dawson began taking prescription medication for low back pain. He continued taking that medication throughout all of those years between 2001 through 2008. In 2004 and in 2005, his physician, Dr. Thompson, diagnosed Mr. Dawson with osteoarthritis and with degenerative disc disease from L2 through L5 in that area of the back. After that, a couple of years later, in 2007, he went to the emergency room with severe low back pain. He went to see a chiropractor, Dr. Wickham. He went to see a pain management specialist, Dr. Lair. All of his doctors confirmed the degenerative disc disease, and Dr. Thompson and Dr. Lair both spoke with Mr. Dawson about that. From 2007 through 2008, during a period of a few months, he went to the doctor some 24 times for this back pain. So the evidence there conclusively established that he did, in fact, have the awareness of his injury that is needed. So what about the second part of the test? The second part of the test, as I said, requires an awareness of the potential cause. If the plaintiff knows or has reason to know that his injury is merely work-related, that is enough to put him on notice and to start that clock running on the 3-year period of time to get his claim filed. Again, our brief at page 9 lays out what the evidence is of that. Before the 2006 retirement of Mr. Dawson's coworker, Dennis Mush, I hope I'm not mispronouncing his name, but that coworker was told that, from Mr. Dawson, that his pain was related to toadstool seats and to rough track. In 2007, Mr. Dawson related to Dr. Wickham on a couple of different occasions that nothing hurts his back but rough engines, that he has been on a rough riding engine, etc. In July of 2007, Mr. Dawson related to Dr. Lair's office that he had had a rough ride on an engine and that sitting on engines made his pain worse. By that time, Mr. Dawson recognized that every time he went to work, these are his words, his back got sore. He felt increased pain after working. And then in August,
What time frame is that?
that is in 2007. In August of 2007, Mr. Dawson related to Dr. Lair that work re-aggravated his pain and it was causing him pain. Neither Mr. Dawson nor any of his doctors offered any other potential causes for his degeneration or his symptoms. So this evidence, too, established Mr. Dawson's knowledge that work was a potential cause of his injuries prior to February of 2008. In fact, as far back as 2005, 2006, he was saying work is related to this back pain. Now, Mr. Dawson's,
Can I interrupt just for a second?
course.
On your chronology? I think we're aware of that. Am I correct in understanding that in FELA cases, railroad cases, the common law negligence standards apply, or in terms of defining the torts? Is that true?
yes,
And at common law, we would have a separate cause of action for an aggravation of a pre-existing condition. Can't you seek damages strictly for an aggravation of a pre-existing condition?
in some states you can. Here we cannot. This is not a situation under the FELA. You are not entitled to recover damages just for the aggravation of a pre-existing condition. And so that's what goes to our rough ride argument that
Well,
we're
so in other words, if I have a pre-existing condition that is barred by FELA because it predates the 3-year statute.
right.
But I do have isolated events that truly aggravate that condition, and I'm not seeking any damages for the underlying condition, just for the extent of aggravation, which comes up from time to time in cases, which would be a separate identifiable claim. You're saying that claim is barred even though it's within the 3-year statute?
If it is an aggravation of symptoms to which he already had notice and it's to the same area, then we don't restart the statute of limitations for that. Our case here.
So you have a claim, but you have no compensable claim for aggravation in that.
Not in this situation, not under these facts, because the timeliness part of this was not met with respect to the cumulative back injury. In other words, he
Even
claims.
if I'm not making the claim for the old back injury.
Correct. He cannot now come in and say, but I had these separate instances that were within the 3 years and I can recover for those. And the reason is this. In an FELA action, the aggravation of an existing condition does not restart limitations. He knew well before 2008, as far back as 2001, 2, 3, that he had a back injury. He knew of its work-related cause. That means that the statute began to run then. These instances that he is alleging happened in 2008 and 2009 are to the very same area of the back. The discs
case
that had
called-
been
I'm sorry, there's a case called Mix versus Delaware and Hudson Railway. I'm sure you're familiar with that, or have had some exposure to it.
I have had some exposure to that case.
What's your answer to that case which would allow?
It was a different injury. The more applicable case is the Henry case that we have cited in our brief, Henry versus Norfolk Southern Railway. It's a 2015 case from the Sixth Circuit where the alleged re-aggravation was for something that had already existed, and that's what we have in this particular case. In this case, the medical records that Mr. Dawson already was suffering increased pain and symptoms prior to his first alleged rough ride, this other instance that we've been talking about that happened in 2008. he concealed that, number one, from BNSF and from the doctors that he saw after that. I mean, he already had been going to the doctor for years for back pain. In fact, a couple of days before this alleged rough ride in 2008, he had already called Dr. Lair to make an appointment in his office. Then he has the alleged rough ride. He reports it to his supervisor. He goes to the emergency room. He doesn't tell either BNSF or the doctors in the emergency room or the doctors that he saw subsequent to that he had been having this back pain for all of those years. It's the very same back area that already had been diagnosed with degenerative disc disease. And so the fact that he now has something else that is causing that means nothing in terms of restarting the limitation period. Those claims are barred just as the cumulative claim is barred.
My understanding is that this gentleman suffered back injuries when he was in the military in the 1980s. Are those injuries in the same location?
It's not entirely clear from the record whether they are or they aren't. We would say that he has an awful lot of other things that have caused him to have back injury, and that gets us into the causation argument that we could talk about as well. But even if you look at just the time that he was working for BNSF, he knew of the injury and its work-related cause long before 2008, and as a result, all of those claims are barred, no matter what else may have happened even before that when he was working in other capacities.
You're bumping up against your rebuttal time, counsel.
Okay, then let me move on to a couple of other things. There are 3 cases that this court has decided recently that have a particular bearing on this appeal. Number 1, Bullock versus BNSF. The court decided Bullock in August of 2015. The Kansas Supreme Court has granted Bullock's petition for review in February of this year. At this point in time, we simply don't know what the Kansas Supreme Court is going to do with the case, but whether or not Bullock is technically precedent, as we discuss it today, really doesn't have any effect on the analysis. This court already has held that the nearly identical argument made by the same counsel in another FELA case was improper. So absent a clear indication from the Kansas Supreme Court to the contrary, there's no reason to reach a different holding in this case. That improper argument was one, of course, as this court knows, that the jury should make its decision based on the values in the community rather than the relevant evidence. That's improper argument. The same decision ought to be rendered by this panel that was rendered by the decision in the Bullock case.
But wouldn't, if we find for your first cause, does that make if we find for your first cause, doesn't that make all the other issues moot?
Yes, Your Honor, it does, and we would far prefer that. We would far prefer to prevail on the timeliness and have all of the rest of this go to one side. But I just thought that if I had some time left, I would talk about some recent precedent.
I understand, but I just want to make sure I was following your.
Absolutely.
But the relief under Bullock would be reverse and remand for a new
Correct. It
trial.
would be a new trial, and we would far prefer to have render of judgment in our favor. Am I out of time, Your Honor, on that?
You're into your rebuttal time. You still got your 5 minutes if you want to end now.
Okay, well, then let me just say as briefly as I possibly can, the other 2 cases are the Smart case and the Farley case that this court also has decided dealing with the way in which expert testimony is analyzed to determine its reliability. We believe certainly that under a proper analysis that there is no evidence of causation because the experts who allegedly provided that material for the court and for the jury's consideration were not giving reliable opinions. In the absence of that, there would be no causation testimony. And so a proper application of Smart and Farley would lead to that result.
So you're talking about the hypothetical question asked by plaintiff's counsel to his expert,
Partly, yes,
because that hypothetical question appears to assume facts not in evidence.
correct. That question has no actual probative value because there were so many hypotheticals included within the hypothetical that have no support in the record, that are not in fact the situation in which Mr. Dawson found himself, that it has no actual value.
You objected to the hypothetical?
We objected to the hypothetical, we objected to the evidence. We said that there was no reliable testimony of causation, and we specifically challenged the experts who allegedly provided that evidence. I will reserve the rest of my time for rebuttal. Thank you.
You have 4 minutes.
May it please the court?
Counsel.
Your Honors, the FELA, as you're aware, is a broad and remedial statute that must be construed liberally to effectuate its humanitarian purposes. And when we're examining the appeal in this case, especially on the first issue of statute of limitations, I think we have to look at it under the appropriate standard of review, because what we just heard was a good argument of things that frankly, Your Honors, don't matter. And here's why. Under the standard of review, this court must look at the facts in the light most favorable to the verdict. You have to disregard facts that don't support the verdict. And you cannot reweigh the evidence. Under the Kansas standard of review, under the FELA, what the courts have held and what the courts have said is factual disputes, if there is a factual dispute.
But that's different than if the court made an error of law in that your client didn't meet his burden of proof to show that his claim fell within the statute of limitations,
Well, Your Honor,
right?
in order to determine that, you have to look at the facts. And once the facts had been submitted to the jury, which they were in this case, and 12 people, this was a unanimous verdict,
The court could have dealt with this issue on a motion before it went to the jury.
if there were not facts that were sufficient to allow submission.
Well, wasn't this, doesn't this appeal encompass the court's adverse ruling on the motion for summary judgment?
No, Your Honor, I believe it goes to the submission of the case by to the jury. The summary judgment, the same result happens, but what they're appealing is the judgment as
Well,
a matter
no,
of
if it's
law.
summary judgment, we review it de novo.
I believe, Your Honor, that when you review it, I believe, Your Honor, that what we're reviewing here is the JMOL, or the denial of the JMOL, not of the summary judgment. Either way, Your Honor, and whether you want to review it de novo or not, here are the facts that were in front of the court for the summary judgment as well as for the trial. Number one, the plaintiff had, and this is in the record, Dr. Thompson, who was one of his treating doctors, who saw him from 2001 through 2006, he had intermittent, mild, somewhat chronic low back issue. Intermittent and mild. What the case is saying, specifically Christensen, which cites to the other federal cases, if you have intermittent and mild pain, that doesn't start the knowledge that you have an injury. It doesn't, under the law. He had that for several years. In 2007, with no triggering factor, nothing happened. He wasn't at work, he wasn't at home. His back started hurting him severely, and he went to the doctor in mid-2007. And when he went to the doctor in mid-2007, one of the things he told the doctor when he went to see the doctor was he checked a box saying it was, in his view, not work-related. He did say to several doctors, or at least to one doctor, I should say, one doctor, he said that riding on rough engines and track does increase the pain, but it increases it above the baseline of pain he already had. The defense says if that happens, then you know it's work-related. The problem with that argument here is he had pain when he was sleeping, and so if you accept their argument, what he should have known was when he sleeps, that's causing him a back injury. He had pain when he would get in and out of the car. And if you accept their argument, that means getting in and out of the car was injuring him. He had pain when he did yard work, and he checked on a form when they said, what causes you pain, one of the doctor's forms. He checked yard work, gardening. So there were a variety of factors. They're saying the pain only happened at work. That's just not the case. The pain happened.
Most people who have back pain have it 24 hours a day.
And it increases.
Go away.
Yes, sir, and it increases with certain activities from time to time. And that's just the point. If you have pain, that doesn't mean you know that you have an injury, and it doesn't mean that you know it is work-related. And none of the doctors, Your Honor, none of the doctors told him it was work-related. And in fact, if you look at the doctor's testimony, Dr. Thompson and Dr. Lair, who he saw in 2007 and 2008, what they said was, we have no opinion and can't make an opinion about whether it's work-related. So even if he had asked them, and they're, by the way, saying he should have asked they're saying the case was basically filed 6 months too late, is what they're essentially arguing. Because we filed it in February of 2008, and the severe pain started in the middle of 2007. And so what they're saying is during that time period, he should have asked a doctor. And if he had, what we know, because the record says this, is that...
Filed it in 2011.
Yes, sir.
You
but
should have filed it sometime in 2010.
It dates back to 2008, February 2008. Yes, sir. I apologize.
All right, I just want to make sure we get the dates right when we're talking.
Yes, sir. Thank you. And so the point is, Judge, if he had asked one of his doctors, Dr. Lair or Dr. Thompson, who he was treating with, they would have told him, we don't know, we have no idea what's causing your back. That's what they testified to in their depositions. They never made a diagnosis that it was work-related. This is not a case, Judge, where he knew it was work-related. This is not a case where he knew he had an injury that was work-related. This is a constructive knowledge case. What they're saying is he should have known. And if you read Christensen, what it says is, in almost every case, if you have constructive knowledge, that's a jury issue, because there are different facts that are out there. There are facts, Your Honor, and by the way, this is important with Dr. Wickham. He saw her a handful of times early on. He didn't see her again in 2007. He saw her early in June of 2007 when he went there, complained of pain from yard work, and then returned to see these other doctors who have no opinion about causation. Under the FELA, to the maximum extent possible under the case law, cases are supposed to be for the jurors. And what courts of appeal under the standard in FELA cases, what courts of appeal are supposed to do is not go pick through the record to try to look for evidence that supports the other side. If a jury finds in the plaintiff's favor, which they did here, and 12 people, and they specifically found there was a specific question where they were asked about the statute of limitations, and they found it was timely filed, all 12 of them did. The judge, when they filed their motion for new trial or for JMOL, the judge also found that it was timely filed. So the people who were there to actually see the witnesses, because Mr. Mush, whose testimony they referred to, in 2006 they say he told Mr. Mush, I have pain due to toadstools. 2006 was where he was having intermittent pain. It wasn't until 2007 that he had the severe chronic pain. So if he told him that in 2006, and by the way, if you look at Mr. Mush's testimony, at first he says, no, he never told me that he had pain at work. That's what it says in the record. So the jury could believe that, or they could believe it later. It was up to the jurors to believe that, or not believe it, as opposed to the Court of Appeals looking at a cold record versus seeing the witness testify. And when you think about what they're trying to say, it is that because a co-employee says that he said that, despite contrary evidence, it's binding as a matter of law. Well, that's just not the case. That's why we have jurors who evaluate the witnesses, evaluate the testimony, and try to determine what they believe is appropriate under the case. They talk about nothing helps and nothing hurts except for riding on the track and rough engines. A few days later, when he went back to the doctor, he said, yard work hurts my back. And this is in 2007. He says, yard work hurts my back. And when he says nothing hurts and nothing helps it, what he's saying is it increases the baseline of pain that came on without me knowing what it came on from. So at the end of the day,
Would you repeat that last? I'm sorry, what
Yes,
you
sir.
just said about causation.
so when you're looking at his back injury, Judge, when you're looking at what did he know and when did he know it, he was having pain from increased baseline pain, increased pain at work, increased pain at home. And so it would lead him to believe, or certainly could lead him to believe, that it was from his activities at home, the increased pain. But that doesn't tell you that there is an injury, because his pain came on without anything happening. It just came on in mid-2007.
So if his pain just comes on, how's it work-related?
Well, that's just it. He didn't know at the time. Later, he went to a doctor in 2010 who told him, you know what, I've seen, and that's Dr. LaSalle, I've seen a lot of people just like you who work at the railroad.
But your expert during that testified it was work-related was based upon a hypothetical that it considered many facts that were not in evidence.
I believe all of those facts were in evidence, Your Honor. We believe there was...
It didn't disclose that he didn't work for the railroad for a period of 6 years.
Well, I believe what he was asked is that he worked for the railroad over a number of years.
Didn't disclose that he had prior back injuries before he went to the work road.
He did. He had all those records. And that, Your Honor, he read every single medical record that was present, or a summary of all of the medical treatment, including that. He did read all that.
Your hypothetical, I don't think, included that question.
Well, we believe it did, Judge. And even if you don't look at that, Judge, on their appeal, they've said that there wasn't sufficient evidence for Dr. Amundsen. What they didn't appeal was Dr. Wickham, who did also give causation. They haven't appealed that. They didn't appeal it. They didn't put it in their opening brief. That is waived. So we have record evidence from Dr. Wickham, who testified that the work caused his back injury. And so whatever you feel about Dr. Amundsen, and we do believe that the hypothetical was proper and had a factual basis for all of it, Dr. Wickham's testimony alone makes the case. And if you think about it, Judge, if Charlie Dawson had
Now,
gone
wait a
to...
second. Let's back up on that question.
Yes, sir.
My understanding is that Dr. Wickham said she could not say to a reasonable degree of chiropractic probability that Dawson's work at the railroad caused his injuries.
That's not so. If you read that quote, Judge, if you look at that page of the record, what she says is, I cannot say it caused it. I can say it contributed to it. That's exactly the quote, Judge. Under the FELA, We don't have to prove it was the cause, the biggest cause, the major factor. If it caused, in whole or in part, even in the slightest, the injury, the railroad is responsible. So please look at the record, Judge. It says, she specifically says it contributed to it. There's no doubt about that.
But we apply a different standard when we're examining the statute of limitations, is that what you're saying?
As far as,
As far as the understanding of the plaintiff, his discoverability of the fact that this contributed in some fashion to his injury, if that's the standard that we apply under FELA, wouldn't that standard also apply in judging whether the plaintiff was on notice of his injury? Not that I've got an ironclad diagnosis, but I believe that it contributed to it, and that's the only standard that has to be met under a.
that you have an injury, not just pain, because pain is not synonymous with injury. You can have intermittent pain and you don't know you have an injury, which he did have. The standard is you have to act reasonably to investigate. Once you know you have an injury, you have to be reasonable. Well, in this case, what we know is if he had gone to Dr. Thompson or Dr. Laird, they would have said, we don't know what caused it. Their expert in this case, Judge, testified that our guy's problem was, as he believed, due to age and genetics and nothing else. That was their hired expert. As a matter of law, is that an opinion he can't give? Is it so unreasonable that he can't? Our client believed he had a worn out back. He was getting older. He did not know it was work-related. If he'd have gone to see their doctor, he'd have said, no, it's not work-related. And so the standard for review, though, here, Judge, is to look at the evidence in the light most favorable. And if you look at the conflicts of evidence, the fact that he had a variety of things that caused increased pain, he didn't know that it was work-related. He's testified to that. In this case, Judge, it was a question for the jury. And the judge appropriately allowed the jury to hear it, which under the FELA is what you're supposed to do to the maximum extent possible. And the jury found for plaintiff, and the judge affirmed that. When you talk about the issue of the aggravation of symptoms or the re-injury, there are two claims in this case. There is the cumulative trauma claim, and there is a separate claim for the three specific incidents, and these are witnessed incidents. The first incident, Mr. Shoemate, I believe it was, his engineer testified, they're going down the tracks, and the engine goes and bounced off the rail. It's not like it was just irregular, because these engines do have vibration on them, and sometimes they shake you around, obviously. This was a separate, specific incident that was caused because they had a defect in the track, and there's no question that was within the 3 years of the suit being filed. So even if you were to find that the case is time barred, which we believe under the evidence would not be appropriate, even if you were to find that, those other cases under the mix case, as you referenced, Your Honor, we would still have a claim for those separate and distinct injuries.
Can you distinguish your situation from Henry versus Norfolk, or is it just the matter that Norfolk's, that's a Sixth Circuit. Where does mix come from?
I want to say it's second or third, and I apologize that I can't tell you, but it's.
So is just a matter of we got conflicting circuit opinions? And,
No, not at all. Henry, and we attached Henry, if you look, we attached, I believe, the complaint in Henry to the brief as an appendix, in the appendix. That is a pure cumulative trauma claim. If you look at the.
Part of the record?
We pulled it from the federal court systems law.
You're talking about it, it's the decision.
The actual complaint that the plaintiff filed in the Henry case, so you could see what the case was actually about. Right. And if you look at that, it is purely a cumulative trauma case. The allegations are purely exactly the same. There's no, it says from these dates he worked in a different yard, but was exposed to the same things. We have a case where our client was exposed specifically on at least the first date to the engine going bang, like that, literally bouncing down and hitting the rail, which is a new and separate and distinct claim as well as the other claims that we brought.
But didn't Henry hold that aggravation was not severable, not a separate?
In that case, it wasn't.
Claim for purposes of considering whether the statute's been met? In
that case, it wasn't. And if you plead a pure case, claim like that, how can you say, if it's a pure cumulative trauma claim, that we have a separate claim? I do believe, Judge, that actually a separate claim should be allowed for cumulative trauma as long as it's within the statute of limitations, but that issue really isn't in this case. As to the As to the other issues in the case with regard to, unless you have any further questions on the statute of limitations issues. As to the other issues that are in the case, how much time do I have, Your
You have
Honor?
another 5 minutes.
I have lots of time. As to the other issues that are in the case, and I must say, we prefer you not reverse on that and render judgment, just since that was brought up in the first part. As to the other issues in the case, they brought up the closing argument.
If we follow Bullock on the closing argument, then it is a reverse and remand.
I believe it's not, because Bullock didn't hold that it was reversible error. It was reversing on other grounds, and it held that that was error, did not say it was reversible error, I believe, Your Honor.
Well, tell me how, if we're talking about closing arguments, how it's proper for Dawson's counsel to appeal to the conscience of the community in making a decision, to misstate the law, to comment on the credibility of the railroad's witnesses, to accuse the railroad of buying science and insinuating Dawson's witnesses would be retaliated against.
Well,
How is that proper closing?
I don't believe that all those things occurred. I know those are in the brief of the defense counsel. I don't believe that's actually what happened at trial.
Well, if you read the closing argument, it's pretty close.
To begin with, Judge, on the first issue that we were discussing, which is the issue of conscience of the community, that argument wasn't made. And more importantly, it wasn't objected to. And it's not fair to a trial court, and this is what they're doing. They made an objection at the very beginning of the argument to something Mr. Cohn was saying. But what they didn't do was follow up with an argument when he was saying the things they now object to. That waives the argument. And that is unfair to the trial court, because now the trial court's going to get reversed for not making a ruling on something they didn't ask for below. That is something that should not be allowed.
You're saying they didn't preserve the objection.
They absolutely did not, Judge. And if you read the closing argument, there's no question they didn't, because they made one argument at the very initial. He said nothing about conscience, nothing about community. And when he made the argument was dealing with the issue of how a jury figures out what is reasonable conduct, not telling you to ignore the law. The McClandon case, Your Honor, what the McClandon case says is, and in that case, the judge gave an instruction saying you should find the defendant guilty if you believe these things unless your conscience doesn't allow that. So under the McClandon case, the court gave an instruction. That is saying you can ignore the law if you want. At trial, we never said ignore the law. We never said don't follow the law. That was not said one time to the jury. What was said to the jury was, what informs your ability to determine what reasonable is who you are as a person, what your values are. That's not asking a jury to ignore the law or not follow the law in any way, shape, or form. As to the defendants, Your Honor, as to the other arguments that were made in closing argument, the issue of the defendants buying the science, they made a huge deal. They brought in a book from the AMA saying the AMA says that this can't happen, work can't cause these injuries. They made a huge deal out of it. They used it with their experts. Now, what the book says is we disavow this. It's only the people who wrote these chapters. It's not the opinion of the AMA. It turns out the people who wrote these chapters went down to a meeting with the railroad lawyers and claim agents where the doctors taught them how do you win these FELA claims. And then they go out and write a book saying work can't hurt your back. And so we believe it was appropriate comment to say, look, they've gone out and tried to recruit people to write these chapters who now they bring another guy into court to tell you that's what it is. So we believe that's an appropriate comment on the evidence. And commenting on the credibility of their witnesses is always allowed, Judge. I believe. Obviously, it has to be within appropriate bounds. You can't
call them liars.
Well, I think you can certainly say that what they're saying is strongly untrue or something to that effect. And I think it's appropriate to comment that what they're saying doesn't match the facts. And I do believe, Judge, that in this case it was within the fair parameters of what the facts were in the case, and not inappropriate. As to the issue, Judge, of the expert testimony, once again, they have waived this issue.
Can counsel attack the integrity of other counsel in closing argument?
Well, I think you can comment on what the evidence says. I think you can comment on positions that are taken. I think you cannot say the other side is lying, the other side's lawyer is lying or is a liar. I agree with that, Judge, and that didn't happen here. As to the expert witness testimony, we have a statute that changed in July of that year. If you wanted to have your case reviewed under Daubert, what you were going to have to do was have a ruling by the pretrial order. They filed a motion under Fry because they didn't realize that the statute had just changed. They filed a motion under Frye. The court held a hearing and rejected their argument about the experts. After that, the day of trial, they came in and said, hey, we realize that the Daubert is actually the right standard. We're asking you to reconsider it. Under the law, they have waived that argument because if they wanted a ruling, they had to do it before the pretrial conference. That's what 457 says. And 456 specifically says, unless the court excludes the testimony, the court shall be deemed to have made the findings. And this goes to their gatekeeping role, Your Honors. In other words, the statute in Kansas is different than the statute in the federal system, than the rule in the federal system. 1 minute. So at the end of the day, if the court follows the standard of review, which is applicable, which is to look at the evidence in the light most favorable to plaintiff, the evidence which is conflicting, the evidence from the doctors, from the plaintiff, and if you look at what the plaintiff said at trial, there's evidence all over the place, and it was for the jury to figure that out. And this court, under the proper standard, should not try to reweigh that evidence. As to the expert testimony, we believe that the hypothetical was factually sufficient. We believe that it was supported by the evidence. And even if it wasn't, there's testimony from Dr. Wickham that they have not appealed, who gives us causation. So whatever you find with the issue of Dr. Amundsen, Dr. Wickham's testimony still supports the verdict. As to the closing argument, we believe it was appropriate, and to the extent that it was not appropriate, if you read it, they did not object. They didn't ask the trial court to many of the things that you've raised. They didn't object to it. And if they don't object to it at trial, it's not fair now to come in and ask this court to do something about it, because they didn't object. And if it was something that was truly objectionable, they have able counsel. They will object. We would ask that this court affirm the verdict in all respects, and I thank you for your time.
Thank you for your argument. Counsel, you have 4 minutes.
Yes, Your Honor. First, with respect to timeliness, we're not asking this court to reweigh any of the evidence. Instead, because Mr. Dawson's claim was untimely filed as a matter of law, we ask that the court reverse and render in BNSF's favor. Mr. Dawson has argued that he could not have known that work caused his injuries because there is evidence that he might have attributed his injuries to some other causes. That argument in and of itself overstates the level of knowledge that is required for Mr. Dawson's claim to accrue. As I said in my opening argument, under the FELA, all it is required is that Mr. Dawson knew or should have known that his work was a potential cause. Mr. Dawson's explicit statements to his treating physicians, to his coworker, that actually related his pain to the work that he was doing, those things are conclusive evidence that he knew or should have known that work was a potential cause of his injury. In fact, this court held in Christensen that this is exactly the type of evidence that would support summary judgment. It's a little tedious perhaps for me to read to you from that opinion, but I think it's important here. A doctor's discussion with the patient regarding the connection of the injury to the patient's work is not necessary to trigger the statute of limitations for an FELA claim, but such evidence, this court wrote, would be a clear indication that an employee was put on notice to further investigate. That is precisely what we have here.
What are you reading from, counsel?
Christensen, your opinion, Your Honor.
Do you know the number?
Yes.
We have a lot of them out there, so it's hard to keep track of them.
Yes, sir. Christensen, the case is, if I can
Unpublished
find,
opinion.
it is, and I've got it for you right here. It is 287 Pacific 3rd 300. It's a table.
That's the Westlaw.
And then it's 2012 Westlaw 5392184. It was from November 2nd, 2012. Christensen.
Now,
Thank you.
maybe it makes a difference, maybe it doesn't. Just procedurally, are you appealing, is your appeal also from the ruling on the summary judgment motion? Or is it the motion NOV at the end, or as a matter of law at the end? What is it that you're appealing?
we have appealed from, and this is in the brief actually at page 5 as well. When reviewing the grant or denial of a motion for judgment as a matter of law, directed verdict, or JNOV, the inquiry is whether the evidence presents a sufficient disagreement to require submission. And that is what we're appealing from. And so,
Which one of those?
well, all of those, and it's the same standard.
All
Was
those
there?
motions, a motion, you made all those motions and they were all denied?
Correct.
Okay, all right.
And as a result, we believe that because there was not submissible evidence, that means that the court should have ruled on this, and this is a case that as a matter of law should have been decided in BNSF's favor. Since it was not, we ask this court to reverse and render in BNSF's favor because, as I've said, the evidence conclusively establishes that both elements of the discovery test are met and that there was not the re-aggravation of an injury. There's been some discussion in my opposing counsel's argument regarding the Henry case. He argues that Henry doesn't involve a separate acute injury like the one that is being alleged here, but because the alleged acute injury here was to the same discs that were previously diagnosed with degenerative disc disease, Henry is precisely on point with this case. It's the same injury all along. All along he's been talking about the same back pain. All along he has been relating that pain to his work. So he can't then come in and say in 2008, oops, something new has happened. It's the same pain. If he didn't think it was something that was the same, why didn't he tell people I've been having this all along? In terms of who told the truth about what, the day of the alleged rough ride, that first one, Mr. Dawson is the one who went to BNSF and said, I've hurt my back, and did not say, and I've been seeing the doctor for years for back pain. Went to the emergency room, talked to the doctor there, saw different experts who were to testify at trial, never told them. For years, I have been having this very same back pain. Maybe it goes up and down in terms of the level of pain, but it's the same injury, the same place, and I have been attributing it to work for all those years.
Counsel, I think we've heard that argument. Let me move to something else before we close because we're out of time.
Yes, Your Honor.
One of your claims is that Dr. Amundsen's differential diagnosis was inadequate
Correct.
because he didn't
Rule out anything.
rule out anything.
Correct.
Do you have any, I tried a lot of these kind of cases, or damage cases. I don't recall anybody ever saying, well, is there a Kansas case that requires a differential diagnosis?
Well,
That you
no.
go through these steps?
I'm unaware of a case that requires the differential diagnosis in Kansas. However, these are cases that are now under Daubert, however we're going to pronounce that. And so we have not been using that standard, and so the level of evidence, the way in which we determined the reliability of the evidence from our experts in Kansas has changed recently, and so that makes it slightly different. But certainly in the cases, if you look back to Smart, if you look back to Farley, even though they didn't deal specifically with that, we are now going to incorporate into a Daubert analysis regarding the reliability of expert witnesses all of the law from the federal courts that have been looking at that, and certainly there are cases describing Daubert that talk about how you have to rule in and rule out all of the potential causes. To come in and say, based on a hypothetical, much of what is not rooted in the record, oh yeah, that is enough to cause this injury. Well, aren't there other things? No, I don't think so. That is not sufficient. That is not sufficiently reliable evidence of causation.
I think I understand. Thank you.
Thank you.
I have one other question.
Yes, Your Honor.
Counsel said you failed to preserve an objection to the nature of the closing argument with the questions I raised. Is that true?
No, it is not. In our case, and if you go back and look at Bullock and read the record in Bullock, if you read the record in our case, the objection was virtually identical. Very early on, we knew where this was going. We made the objection. It was pretty much the same objection to pretty much the same argument that had been made in Bullock, and this court determined that sufficiently preserved the issue. We did make the objection. We did not waive it. And as a result, that is an issue, too, that should be decided in our favor, although we would certainly pray that the court would reverse and render judgment and make unnecessary a new trial.
Thank you.
Thank you very much for
Thank
your
you.
arguments.
Appreciate your time.
We'll take the matter under advisement. Have an opinion out for you in the morning.
Appreciate that.
Or not. I wouldn't.
It'll take longer than that to get through the reporter's office. Have a good day.
Our last case for the afternoon is 114391 in the matter of the adoption of FRH. Appearances, please.
May it please court, Your Honor. Richard Klein on behalf of JH, the appellant and natural father.
Thomas Merritt appears on behalf of the step-parent petitioner, the Henry Biles, who's also here.
Mr. Klein, do you desire some rebuttal time?
3 minutes, please, Your Honor.
Got it.
Thank you, Your Honor. Your Honor, this is a case of a step-parent adoption where the natural father's parental rights were terminated. In this case, what occurred was the mother and father were living together. They were never married. They had 2 children. At the time of the trial, in this case, the children were 8 and 9 years old. The mother and father had lived together for approximately 5 years during the course of their lives with the children. About 3 years into them living together, the father became ill enough that he wasn't working, and he became the full-time caregiver to the children for the next 2 years, while the mother was the primary worker in the family. After they'd lived together for about 5 years, in the summer of 2011, there was an incident that occurred. And the incident was the father attacked the mother, injured her severely with a knife. He fled the country, came back into the country, was picked up, I believe, in the Houston area, brought back to Missouri. The parties were living in Missouri at the time they raised the children, and then he was incarcerated shortly thereafter, beginning of 2012.
Was that for the attack on the mother?
That was for the attack on the mother, Your Honor, yes. So when this petition was filed, he was still incarcerated, and it's not disputed that while he was incarcerated, he made minimal efforts, or potentially while he was incarcerated, very little effort to stay in contact with the children. And that's not in real dispute, Your Honor.
Minimal, very little, or none?
When he first was brought back and put in jail in Missouri, awaiting, working out that case, he attempted to contact the children by telephone. That telephone number, the mother's telephone number, had been changed. The mother had moved from that point. He testified that he sent his father at least one time to the Kansas City, Missouri area to try and locate the mother, but she'd moved. It turns out she'd only moved a few blocks, but a few blocks may as well be out of the country if you don't know where to start looking for somebody after that. And there was also no contact order, which I think I'll push to the end of my argument if I could. I believe so the district court held a hearing, terminated the natural father's rights, in essence for 4 reasons. I believe the first 3 reasons were improper as a matter of law. So the judge properly went to KSA 59 2136 H1, and he used 3 of those factors to terminate the father's rights. The first one he went to was 59 2136 H1B, and terminated his parental rights for unfitness. In coming to his unfitness conclusion, he went to the Child Needed Care Code, which is typically acceptable by this court, and it has been used in a number of cases. And at times, it's probably an acceptable way to do it. In this case, it wasn't, because The two sections he used in the Child in Need of Care Code were 382269B1, which is, which he considered the father's incarceration as a physical disability. I'm not sure how I'm not sure how he came to that conclusion, but that was his conclusion. And without being completely disrespectful to the district court, I will say that is an unfounded conclusion that incarceration is a physical disability under the law. The second factor he used,
Be an inability to parent the children on a daily basis?
but it's not a physical disability, Your Honor. A physical disability is a wheelchair or a lost limb or lack of eyesight.
Well,
I
that's-
mean, the SINC code defines that fairly clearly, I think. I mean, being incarcerated is absolutely not a physical disability. I don't think you could, I don't think
But it is a separate reason for termination of parental rights.
a physical disability.
No, incarceration.
It is, Your Honor, and that would be under, in the Child in Need of Care Code, 382269B5 allows for a finding of unfitness for conviction of a felony and imprisonment. Now, implicit in the Child in Need of Care Code is also other findings before you get to termination that the judge didn't make here. But the fact of the matter is, in adoption cases, the case law very clearly covers the requirements that a parent must make if they're incarcerated. I would argue that it's just improper to use the SINC code to flat out say that felony, imprisonment, I can find them unfit. Beyond the fact that under the SINC code, you also have to find that that unfitness is unlikely to change in the foreseeable future, and it's not in the best interest of the child to maintain the parental relationship also, which those findings he didn't make. It's just, given this case, the factors from the SINC code just don't apply. The other one that he used, Your Honor, was 592136H1C, which is no reasonable efforts to support or communicate with the child after having knowledge of the child's birth. I mean, the case law is pretty clear in this also, that these are cases dealing with children who are born and the parent doesn't come forward after the birth. In this case, the children lived with him for the first 4 or 5 years of their lives. He took care of the children. This subsection of the statute is just not applicable in this case, I believe, as a matter of law. The third one is the real
But
debate.
why wouldn't it be applicable during the period of time that he ran to Mexico and was gone for the children's life between 2011 and when the hearing occurred for the adoption of the children? Because he had no contact, he had no support.
That's what the next subsection he used covers, Your Honor. That subsection, H1C, is in the case law tracks that. It's for infants whose fathers don't step forward after they either had knowledge or should have had knowledge of the birth. I mean, it's not for parents who took care of the children, while the mother was pregnant and after the birth of the child. Those cases all are infant cases. All are fathers who didn't come forward immediately when the children were born. Those cases just simply don't apply in this case. He's stretching that to include time after the children were 4 and 5 years old in 2011 when he left, which is really what subsection G covers in this period, the 2-year period of time.
Counsel, what did the father fail or refuse to do? We have this situation that for 2 consecutive years preceding the filing of the petition, he either failed or refused to assume the duties of a parent. I guess mainly because he was on the run.
Well, that brings us to subsection G, Your Honor. And that is the period that he was incarcerated. There's no dispute that he was imprisoned in Missouri for really the 3 years before the filing of the petition. And an issue now is that, given that the mother moved, didn't have the same phone number, there was a no contact order in at least the beginning of the case where the father simply couldn't contact the children. The only contact he could have with the children would be through the mother.
But he was in Mexico.
Not at this point. When he came back, you're right, Your Honor. During the period he was in Mexico and that was about not even a 1 year period. He didn't care for the children. I don't think there's.
Since we're talking, as you said, talking about children who are ages, 8 and 9, he could contact them directly, couldn't he? If he wanted to.
At the time of trial, they were that old, yes, Your Honor.
Well, all right, so that they were a year younger or 2 years younger. The point is, he never sent him a birthday card, never sent him a letter.
Didn't have an
never-
address. Didn't have the phone number.
Didn't he have their grandmother's phone number or address?
I don't believe he did, Your Honor. He certainly didn't have the mother's, and he didn't know that the mother was living with the grandmother.
Well, if you couldn't find the mother, I suppose contacting her mother might give you some information. He never attempted to contact, to pursue this, other than he did make one phone call that was not returned. Is that right?
Yes, Your Honor. While he was in jail in Missouri, waiting to sort out the Missouri case.
And that was, I think it was that an answering machine that he left a message on and never was responded to?
Yes, Your Honor.
So he knew, I presume that he recognized the voice, I don't know, but was that the voice of the mother on the answering machine or the grandmother? Do we know?
We don't know, Your Honor.
But there were no other efforts to, set up a bank account for the kids, or even if you put in a few bucks.
He did not do that, Your Honor. He did have his father go to Kansas City, Missouri at least once to try and contact and find the mother. And when he went to the address where she lived and she wasn't there, I think that for almost anybody, that would put a complete stop to the search.
I think we recognize that when a person's in prison, they can't fully exercise obviously fulfill the duties as a parent, but they're supposed to do whatever is available to them. Were some of these things available to him? That is, sending a birthday card or something like that?
He wouldn't know where to send it would be the issue, Your Honor. I mean, so you have a father who is in jail, attempts to contact the mother, doesn't know where she is, believes he has a no contact order that's going to last at least a year, typically would last 2 years. So he doesn't think he can contact the mother anyway, and which is the only way he can contact the children is through the mother. And
He
he's
knew
really
the grandmother's address and phone number, didn't he?
I don't believe he did, Your Honor.
Sure?
No, I'm not. To tell the truth, if you're reading that, then
I might be bluffing.
you're looking down and
Well, while you're looking for that, the sort of the elephant in the room that we haven't discussed is the fact that as soon as this guy gets out of prison, ICE is going to be standing on the doorstep, ready to take him into custody and deport him to Mexico. Is that correct?
yes, Your Honor. I'm not sure that means he shouldn't or can't have a relationship. It may mean he shouldn't, but it certainly doesn't mean he can't have a relationship with his children. I mean, I would suspect many families who are. I mean, we deal with this all the time with the Hague Convention. Well, we don't. I don't. I'm sure the court does. There are children who live overseas and visit the United States, and children whose parents live overseas and they go visit them overseas. There are some practical issues, obviously, with that, but it certainly doesn't mean that they can't do it. But the real, and Judge, my understanding, as I look through my notes, is that the grandmother moved from the residence where she had been living in 2013, so about a year after he went to prison. when you start looking at these prison cases, I mean, they're kind of, these are some different types of facts. I mean, this is a guy who attacked his children's mother. I mean, he's not super sympathetic. I understand that, but I mean, they're still his children. There's no evidence that he abused the children or was unkind. I mean, even the mother acknowledged that he loved the children. I think she called it, albeit a different type of love. He took care of the children for a significant period of time of their lives, and what happened, and then he goes to prison. He has, in essence, no way to contact the children. I mean, I think the law requires him to make efforts, but it certainly doesn't require him to make Herculean efforts to contact the children.
You're into your rebuttal time. I'll give you your rebuttal time, but
I'll end on that, Your Honor,
All right.
and wait for rebuttal. Thank you.
thank you. You got you.
May it please the court.
Counsel.
Good afternoon, Judge. I'd like to go through some of the items that were spoken about earlier before I get into the crux of my argument. I think it's important, and I know that you don't like us to get into facts, but for the purpose of the audience today, this wasn't just an attack. This wasn't your run-of-the-mill domestic violence situation. This was an attack with a knife that left Mom in the hospital for 3 days. He was originally charged with attempted murder. He ended up pleading to felony domestic assault and felony assault with a deadly weapon. And so I think the first argument that the court has to deal with is what's the proper statutory requirement to analyze this case under. And Judge Joyce, at the district court level, analyzed it under several different levels. And I think Mr. Rich was wrong in regards to the first three statutory requirements being inaccurate. And frankly, I don't think it matters, though. There was some case law as recently as 2 or 3 years ago that said you use 512136D, and then that changed to 512136H. So whether you use D or H, or whether you use subsection B, C, or G, I don't think it matters. And the way that I would explain it is it's kind of like if you're going to Lawrence from Kansas City. It doesn't matter if you take K10 or I-70, you're going to get to the same place for all of these, no matter which way you analyze it. And that is that the bottom line is, since the time of incarceration of this man, he made one phone call, an alleged phone call. He has provided no communication to the children. He has had no relationship to the children. He's made no effort to financially support the children. And in 2.5 years, when he's released, the ICE agents are going to be at the prison waiting to take him to Mexico. For all intents and purposes, I think this man is probably gone for the rest of these children's life, and he's made no effort to be in their life since incarceration. Now, Mr. Rich made the statement that the court does say that, and I believe it was Judge Malone in a previous case, that if an imprisoned parent has made a reasonable attempt to contact and maintain an ongoing relationship with his or her children, it's for the trial court to determine the sufficiency of such efforts. And Mr. Rich says it just has to be reasonable. It doesn't have to be Herculean. I would argue in this case it just has to be an effort. He hasn't made any effort. There was one phone call 3 or 4 years ago. That's a far cry from what any of the case law says is sufficient to justify a reasonable effort. There's the case that we quoted in our brief, Judge, which is the case of In Re SD. That's the CanApp 2D 780 case. And in that case, the mother had sent cards, the mother had called the children. She'd done a lot more than what this biological father has did, and the court still said that's not sufficient. So I think the other elephant in the room, Judge, is the fact that the court used this unfitness statute where we switch over to the Child Native Care Code, which I think was proper, and it's done all the time by this court, it's done all the time by district courts, is there isn't a statutory definition of what unfit is in Chapter 59, so you switch over to the Child Native Care Code that does have a definition of unfitness. And one of the definitions, without getting into the details of all of these other statutory avenues that the court took to find a termination of his rights to be appropriate is just this general idea of 592136H, just father is unfit, and then the unfit definition is felony and imprisonment. So without getting into the murky details of these other items, the fact that he committed a felony and is imprisoned in and of itself is enough for the court to find him unfit. In fact, Judge Malone, in a Court of Appeals case, In re MB, stated that father's incarceration alone can be sufficient evidence to support a conclusion of unfitness. So I don't believe that's outside the boundaries of what this court has found before, so I don't think it's inappropriate for the district court to use that either. And I'd like to talk a little bit about the case law that the appellants have used in regards to the efforts of previous parents who have been found to have made a substantial effort and therefore not had their rights terminated. If you read those case laws, Judge, they have arranged for, in one instance, they arranged for the Salvation Army to send presents to the kids every year. They arranged for their family members to send presents to the kids every year. They sent weekly letters to the children. They spoke to the children on the phone. They sent birthday cards. They had family members go and get gift cards to send to the children.
But we have, the argument is, we didn't know where they were. We didn't have an address, no way of contacting them.
And I think that argument doesn't hold up, Judge, because he and Mom lived with Grandma, and he had that address. Now, granted, Grandma changed her address a few years into his incarceration. There were avenues that he could have taken to find where these people are. He also had the phone number. He called them previously, left a message, never did anything else. So I don't think that argument holds up. I also don't think this argument of a no-contact order holds up either, because first of all, there was a no-contact order at the beginning of the criminal case in Missouri. That no-contact order was between biological mom and biological father. There was never a no-contact order between biological father and the children. I believe at the trial, biological father stated, well, that's what my lawyer told me, is that there was a no-contact order. That was never corroborated, and I think Judge Joyce even mentioned there was no evidence to say that that was true. So this idea of, well, he wasn't allowed to talk to his kids is not substantiated by any of the facts. And I think at the trial court level, that's something he really hung his hat on, was, hey, there's a no-contact order. I couldn't talk to my kids. That's why I've never called them. That's why I've never sent money. That's why I've never sent a letter. And that's just not the case. There wasn't a no-contact order. There never was a no-contact order. So. I think the court has, I think Judge Joyce at the time, I know that my client and I were, for lack of a better term, a little grumpy at the time it took to write this decision. But when it came down now, I see what he was doing. And that is going through and very specifically stating that given the facts of this case, there are several different statutory avenues that the court could take to conclude that the biological father's rights should be terminated. What we have here is a situation where biological father attempted to kill mother, was charged for that. He has since then never seen his children, never talked to his children, and at the end of his prison term in 2 years is going to be deported to Mexico. In that time, my client married their mother. They've been married for several years now. He is the children's father. The biological mother testified that the children call him dad. He coaches their baseball team, and he stepped up to the plate and tried to adopt these children. And that was going on 8 months ago, and now we've had put all of these barriers in place where this man who's been the only father figure to these children for the last 4 or 5 years, and for all intents and purposes is going to be the only father figure moving forward, has tried to do the right thing, and we've gotten bogged down in these statutory proceedings that biological fathers continue to oppose the situation, appeal the situation, and I think from a practical standpoint, what the court can also do that Judge Joyce didn't really get into that much, but the last statutory requirement, the last statutory avenue that the court can take is when looking at an unfitness determination, the court can look at 382269G1, and that's just a general idea of best interest of the child, which is the threshold that we oftentimes use in child need of care cases, domestic cases, is what's in the best interest of the child. And so while we talked about the 4 or 5 other statutory avenues that the court can take to find that this dad's rights should and rightly were terminated so my client can adopt the children, the one that we didn't really get into is what's best for these kids. And that's there's 2 kids who have a step-parent who they call their father, who they refer to as their father, who they feel is their father, who wants to be their father. And so I think from a 50,000 feet view, how can that not be in the best interest of the children?
You're not suggesting that that could be a primary basis for terminating the rights of a parent.
Well, I think the best interest of the child threshold, according to 382269G1, is it's just the statute just is a general, is it in the best interest of the child?
That's as to termination of parental rights, not as to granting of an adoption.
I agree, but in this situation, Judge, I think what that would mean is if it's in the best interest of the child to be adopted, then the avenue that the court has to take is to terminate that. And so I think it's a causal relation.
Well, you're not saying that based solely on the best interest of the child, you can terminate parental rights. I used to handle some of these things, and even in handling domestic cases generally, there are a lot of kids I think I could find some better parents for.
I know, I don't disagree on that.
But I don't think it's the business of the government to go around and taking people's kids away just because we think we can find somebody better for them.
I agree, but I would recommend, and the statute I'm referring to is 382269G1, but it does at the bottom of the statute kind of have this general all-encompassing, is it in the best interest of the child? And so, like I said earlier,
Do you have children?
I don't. I've been married for about a month, so I really don't know what's going on when it
Come
comes to
back
that
when you
stuff.
get some kids, and I think I can find a better parent than you out there. So I know you'll be a fabulous parent, but there's always somebody better over the horizon.
No, I agree. But what I'm saying is that we have all of these, like I said earlier, for instance, we have all these roads to go to Lawrence. We have all these roads to find that dad's rights should be terminated. But there's also at the bottom of the statute this other way that you could do it. And that wasn't really mentioned by the court. And so
Counsel, what are the ages of the children now?
they're 8 and 9 now. I think one of them's had a birthday. So they were 3 and 4 when Dad got arrested and went away, but they're 8 and 9 now.
And when was the last time they saw their father?
The day of the incident. That's the other thing that didn't come up that I think was in both of our briefs is this occurred in front of the children. The children saw the incident back in
How long ago was that?
July of 2011.
So they haven't seen their father for like 5 years?
It'll be 5 years in July. And it's not just a matter of they haven't seen him. They haven't had any communication. They haven't got a letter. They haven't got a phone call. So they've had nothing from Dad since July of 2011. And I think that goes a long ways because really the statute only looks back 2 years. And so whether you say, hey, Dad didn't know where Mom was, Dad didn't know Mom's phone number, which I don't know if that really holds up. If you go back before when he did know what it was, more than 2 years ago, he still didn't have any contact with the children. He fled to Mexico. Then when he came back across the border in Houston, he got picked up. And even while he was in Mexico and Houston, prior to being incarcerated, there was no contact with the children. So, Judge, I think I went over my time. Do you have any more questions for me?
Thank you for your argument.
Thanks, Judge.
Rebuttal. You have your 3 minutes.
Two points quickly, Your Honors. The first one is you may not terminate parental rights based solely on the best interest of the child. I think the law is pretty clear on that, both in the Child Needed Care Code and the Adoption Code. I don't think there's any question there. I agree with the court that you can always find a better parent for the children. That's just not the way the law works. The other point, Your Honor, judges, is that in a case where a parent is incarcerated, it's proper to look back at events that occurred beyond that 2-year incarceration period if that parent has been incarcerated for the entire 2 years. If you go back to the events that occurred prior to his period of incarceration, he was a pretty decent dad. And the fact
Prior
that
to the events of the July 2011.
Probably a more fair way to say that, I agree, Your Honor, would be that prior to July of 2011, he was a pretty decent dad. And there was no doubt that he was taking care of the children on a daily basis. He loved his children. He was involved with the children. He did things with them. And I think that the district court did not go back and look at that period. Judge, I'll end on that, unless you have any questions.
Thank you very much.
Thank you.
Thank you for your argument. We'll take the matter under advisement. That concludes our docket for this afternoon. We are adjourned. Thank you all for coming.